Well, welcome everybody. Welcome to Murfett Legal's Preparing for the Tsunami Q&A webinar. Joining me today is Mike Frampton and Henry van der Westhuizen. I got your name right this time.
That's pretty good.
For those of you that don't know me, my name's Kelly Parker and I'm one of the directors and owners at Murfett Legal here. I'd like to start by recognising the traditional owners of the land from which you might be joining us today. For many of us, that is the Whadjuk people of the Noongar Nation, and I pay our respects to their elders past, present and emerging. So a little bit of housekeeping just to get started. As you're aware, the topic today is preparing for the tsunami, and it's considering some of the measures you can put in place to mitigate the impact for when the government stimulus packages stop in the next couple of months. Our webinar will be for 1 hour. And it's in a Q&A format. We are recording today as well. The Q&A, we have prepared some questions that we'll be asking one another. If you've got any questions throughout the seminar, feel free to pop them into the chat bar or just unmute yourself and chime in. We're going to try and keep this as informal as possible, so it's a bit more of a conversation rather than us just talking at you. Bear with me if I get a little distracted. I am answering questions as well as trying to let people in and out of the meeting as well. So without further ado, I think that we will kick off, and we're going to start off with Mike Frampton. And my first question for you, Mike, is the effect of COVID-19 on many businesses has been cushioned by the state and the federal government assistance programs provided to businesses. This assistance is coming to an end probably in September, but it's being mooted that that date might be brought forward. What do you think businesses should be doing now that they can prepare for when the government assistance dries up?
Thanks, Kelly, and morning to everyone. Thanks for dialing in today. Clearly, most businesses will have already started to put in measures or have already put in measures. They would have been reviewing their operations quite thoroughly. They would have been looking to reduce costs.
Mike, you with us still?
I'm here. Yeah, can you hear me?
Yeah, you just froze for a little bit there.
Oh, okay. Sorry, wasn't me. So the businesses will have been looking into what they should be doing now and putting in some mitigation factors now, including reducing costs and making sure that they're making use of all the government packages that are there, both state and federal. But part of that whole process is looking at their contracts and considering how COVID-19 may prevent or delay the performance or complying under complying with their contractual obligations under their existing contracts. It may also mean that compliance with those contracts will become more expensive because of the circumstances that we're now faced with. So businesses should really be analysing their supply chains and looking at their contracts to spot any vulnerabilities and whether their suppliers or themselves can actually comply with their contractual obligations. And then in that process, they would look at whether they need to suspend performance of their contractual obligations, whether they need to terminate the contract entirely, or whether they should be looking to negotiate the commercial terms of the contract. Obviously, each contract is a case-by-case evaluation, and you need to look at the operational, the financial, and the reputational impacts that these sorts of reviews and decisions will have on the business.
Okay, so when we're looking at our commercial contracts, what sort of clauses should we be considering when we're reviewing?
Yeah, each contract obviously has its own peculiarities, and you'll need to view the contract as a whole in the context of the business, how important it is to the business. But there are specific clauses within each contract that you need to look at. Probably the most obvious one, and the one that's been getting a bit of publicity, is the force majeure clause that are contained in most commercial contracts. And we have seen evidence of parties relying on these types of clauses, particularly in the timber, LNG, and copper industries. Certainly, we've had to look at specific goods supply contracts where they're seeking to rely on the clause as well. It should always be remembered, if you're looking to rely on a force majeure clause, that's not going to relieve you from your current financial obligations. We had a situation where a client had been asked to consider a force majeure clause. Their customer was saying, well, they can no longer make payments for the supply of goods that they had already received, and were looking to suspend the operation of the contract. And that was all very well, but we had to remind them that it didn't actually suspend their current financial obligations. So they'd received goods, they needed to pay for those. So the negotiation of the payment then is sort of falls outside the clause, notwithstanding that the contract going forward might be suspended. It's not going to suspend what's happened in the past. So that's something that you do need to consider. Typically, a force majeure clause allows a business to determine whether the event, in this case the pandemic, will have an effect on their ability to perform, or whether it will delay the performance under the contract. A provision is likely to say that a party will be relieved if it prevents or delays from performing its contractual obligations. It is due to a circumstance that is not within the reasonable control of the affected party, and where the affected party is not reasonably able to prevent or overcome the event or circumstance by the exercise of due diligence. So the three aspects effectively are that it must affect your performance, must be beyond your control, and you must not be able to be in a position to overcome the particular issue. So when you're looking at the particular provision in your contract, each force majeure clause is likely to be different. You'll certainly get ones that list a whole specific range of circumstances, which would include epidemics, quarantine, acts of God, whatever an act of God is. I actually heard on the radio a few days ago a priest commenting on what an act of God is, and he was very put out because he felt that everything was an act of God, not just the bad bits. So that's open to definition as to what exactly an act of God is. But effectively, it must prevent the ability to perform. It must be beyond reasonable control, and you shouldn't be able to be in a position to mitigate loss. Now, this is not going to include situations where you have a lack of finance, or an inability to borrow, or you've got a particular hardship. It's actually a situation where you're not able to perform under the contract. And it should also be remembered that it's often just a suspension, not necessarily a termination. And it'll suspend the performance for the period of time that the particular circumstance exists, in this case, the length of time that the pandemic exists. So parties shouldn't necessarily review this as a way of terminating a contract entirely. When considering your force majeure clause, you must also look at whether there is any notice requirements under the contract. Typically there are. You need to notify the other party that you're seeking to rely on the particular provision. You would normally have to give details of that circumstance and how it affects your business and your ability to satisfy your obligations. And again, you would indicate whether it's a suspension or you are seeking a termination. There is usually, together with notice, an ongoing obligation to provide information on a regular basis. So as things change, how does that affect your business? And again, where it's a suspension, it doesn't necessarily suspend previous financial obligations under your contract. Generally, a clause will require you to try and mitigate the effect of the force majeure. So would usually be a requirement for you to take reasonable endeavours to mitigate the effect of the event. And again, that depends on the nature of the contract as to what sort of mitigation would be involved. But clearly, where you are in a position to reduce the effect of the circumstance, you would have an obligation to do so. And as I've said, the relief it's either relief or termination under when you elect to make use of the force majeure clause, and typically it would be for a period of suspension rather than termination. But what is important is that each contract is different. So within one business, you'll have a number of commercial contracts. Each one of those contracts are likely to contain a different type of force majeure clause with different obligations. You need to review each one separately and determine how that clause affects your business. So that's probably the primary clause that you would look at, Kelly.
Okay, so one of the things that you mentioned, Mike, was that even if the force majeure clause is coming into play, it doesn't actually deal with monies owing that under the contract. It doesn't stop the payment of that. Henry, can you just give us a bit of a rundown of what steps that clients could be taking to make sure that they're secured when they're dealing with their clients or customers?
Thanks, Kelly, and good morning to everyone. Firstly, it's vital that business owners should review their contracts and their terms and conditions to ensure that their interests are protected. These documents should make provision for the business to enjoy security interest over the personal property, which security can then be enforced in the event of default by that customer or insolvency of that customer. It is also very important that the business should perfect its security by registering the security interest on the register, the PPSR. This will ensure that the business is a secured creditor and enjoys priority over the other unsecured creditors in the event of insolvency.
Okay, so you mentioned personal property. What does that mean? Are we talking about just the assets of the company?
So personal property is defined in the...
Are you still there? Because I think you've frozen.
Can you hear me, Kelly?
Yeah, I can hear you now.
All right. So personal property is defined in the PPSA. In general terms, it is mostly property that is not real estate. Personal property could be consumer personal property as well as commercial personal property.
Okay, so we are just looking at the assets within a business, right? So the plant and equipment, those sorts of things. That's
correct, and it could be property as at the transaction date and property going forward.
Okay, and just we've got a range of people that are joining us today. Just quickly run through the difference between a secured creditor and an unsecured creditor for me.
If we use the example of insolvency, let's say a company should go into liquidation. You have creditors that enjoy security and you have those that do not. So the creditors that enjoy security will have priority over the unsecured creditors. So when it comes due for dividends to be paid out, they will get preference, and whatever remains will then be distributed pro rata amongst the unsecured creditors.
Okay, so we're talking about a secured creditor standing at the head of the line to get paid.
Correct.
Yeah, okay. So now you talked about registering a security interest. What are we registering it on, and what have we got to be careful of when we're doing those registrations? Okay,
so registrations are done on the Personal Property Securities Register, more commonly known as the PPSR. So what is very important is businesses should ensure that the customer contracts they have constitute as a security agreement. Now that once again is defined in the PPSA. So your PPSA clause should be well drafted and it should allow for your business to register a financing statement on the PPSR. And just another side note, a well drafted PPSA clause will allow for certain provisions of the PPSA to be excluded, which results in a lesser administrative burden on the business in question. businesses should take really good care when they register their security interest on the PPSR. The reason for this is the PPSR functions as a notice board of security interest over personal property. It's not a register storing copies of all those underlying security agreements, and therefore the accuracy of the registration, especially the details of your customer and the collateral in question, are very, very important. When a business transacts with let's say a corporate trustee of a trust or on behalf of a partnership, the customer identifier on the PPSR should be the ABN. When a business transacts with a commercial entity in its own right, then the company's ACN should be the identifier. It is also very important when you complete the collateral section on the PPSR to take care. An example of a motor vehicle, you would need to include a serial number on the PPSR, which can be the VIN, chassis number, or manufacturer's number. So it's also very important to get those absolutely correct. And another very important thing about the PPSR is, as a general rule, the registrations need to be effected within 20 business days from the date of the security agreement. And businesses should take care to ensure that they have protocols in place for those deadlines to be met.
Okay. I've just got a question from Paul, and he's asked, if directors inject capital into the business to support cash flow as a director loan, would you suggest the director registering their security or interest on the PPSR? I'm just going to field that question and say, yes, you should be.
Absolutely.
Yeah, you should be documenting the loan in writing, and then registering your security interest, Paul, to make sure that you are standing at the head of the line to get paid if the worst happens, basically.
Absolutely.
Okay, so from what you were saying, Henry, we've got to be quite precise with our registrations on the PPSR. I've heard it referred to as it's a perfect match search system. So even if you transpose numbers, your registration, it could be invalidated. Can you talk to us about some examples of failing to actually put your registration on properly?
I can give you an example of a recent matter that we dealt with at Murfett Legal. We were instructed by a liquidator acting on behalf of a company that went into liquidation. In 2015, pursuant to a loan agreement, 2 lenders lent $1 million to the company. The lenders failed to register their security interests timeously, and within 6 months of them actually registering the PPSR, the company went into liquidation. So the failure of the lenders to register their security interests timeously resulted in them losing their priority, and then they became unsecured creditors of the company in liquidation. Eventually, the claim was settled for around about 15 grand, I believe. But had the lenders registered their security interest in time, they would have obviously enjoyed priority over the unsecured creditors and potentially would have had a much larger dividend from the liquidation of the company. Okay.
So it's quite serious if we don't get it done properly. I think I've also just been dealing with a matter where somebody purchased a rent roll, and the lawyers for the purchaser have recently said, we purchased that free of encumbrances because we did a search of the ACN of the company, and there were no registrations. The problem was that the rent roll was owned by the seller in its capacity as trustee of a trust, and as Henry said, you're required to register against an ABN when you're dealing with a trust, and as a result, that transaction is now being undone because it's been taken subject to the security of the seller. So some really serious ramifications if you don't get that quite right.
Absolutely, Kelly. The regulations, the personal property securities regulations, give you the guides to follow, and you need to do it against the ACN if it's an entity in its own right, or if it's in a trustee capacity, it's the ABN. There's quite a famous case in New South Wales Supreme Court of One Steel Manufacturing. In this specific matter, it was dealing with crusher equipment, which was supplied to One Steel and was funded by a company called All Leasing at a total cost of excess of $20 million. All Leasing did a registration, an employee of All Leasing did that, but unfortunately, reference was made to the ABN of One Steel as opposed to the ACN that was required by the regulations. The results were that the PPS registration was defective. The iron ore equipment vested in One Steel immediately prior to liquidation. And unfortunately, then All Leasing had to stand in line with the other unsecured creditors.
Yeah, so it's some really serious ramifications. And I think actually registering a security interest, I mean, you've got to get your clause right first, but the actual registration can be done really cheaply for about $15 on the PPSR website. But because of the serious nature of getting it wrong, it is sometimes best to get some advice about getting that registration on properly, I think.
Absolutely.
And Henry, when you're doing a search for charges, it's important you search all three, you know, ACN, ABN, and just the name itself, because some charges seem to be registered against the ACN and not others. You've got to look at all aspects, don't you?
Absolutely. I would recommend to clients that when they want to see if there are any charges, any security interest over the goods, that they do all three. And by all three, we mean if it's a company, you do it against the name of the company, the ACN and ABN. It's a little bit of an extra cost from the on-go, but I think it's worth it. It's really not that expensive at all. But it just gives your client a broader picture of the company in question.
Okay, well, thanks for that, Henry. Mike, I just want to come back to you. We talked about some force majeure clauses, and then we've talked about that not affecting the payment, some security for payment. What about the doctrine of frustration? So we might not necessarily have a force majeure clause in the contract, but the contract could be frustrated anyway. Can we just talk a little bit about what that means?
Sure. Just before I get onto the doctrine of frustration, the force majeure clauses would only be one clause that you might consider. There would be others that you'd be looking for in your contract, perhaps not quite as obvious ones. A lot of contracts actually have hardship provisions, where one party is undergoing hardship that's grounds for a termination. Often contracts have just a provision which allows for termination on convenience. Now that might be by giving the other party notice so that the contract comes to an end within a certain period of time. There may be a process that's contained within the agreement to allow for variations of the contracts, such as often in construction contracts. But those types of clauses may also allow for some sort of renegotiation. You also want to look at things like change of control clauses within a contract, because given that we're in a difficult times, you may find that one or other party to the agreement has either brought in a new equity partner into the business, or they've merged with another business, and those types of actions can actually result in a right of termination. So we've been dealing with one just exactly on those in those circumstances where we were acting for a supplier of goods. The customer merged with another big company and resulted in a change of control, and that they then gave us the right of termination of the contract. So those sorts of clauses are also really useful to look at. Likewise, material adverse change clauses, and these are often found in finance documents where the circumstance is such that it is going to make it difficult for the borrower, in the case of a finance documents, to actually satisfy its obligations under the particular loan or finance facility. An example of this would be where the material adverse clause allows for a termination where the business operation, property condition, financial or otherwise, or the prospects of the borrower has been materially affected. And it may also just relate to the ability of the borrower to perform its obligations under the loan document. But what is important, though, is that the event is significant. You can't just rely on small things that may or may not affect the business. There's recent case law, English case law, which supports the concept of it being a significant event, which has the effect of either bringing the loan into default and therefore making it immediately payable, or allowing the lender to elect not to advance initial monies or further monies to the borrower. And both of these circumstances can provide real difficulties to the borrower. So the lender needs to have sufficient justification for doing so, so that the event must be significant. Because it obviously can put the borrower into liquidation and seriously affect the borrower's ability to carry on business. So a materially adverse event clause is also something that needs to be considered, and particularly in your finance documents. So if you've done a thorough review of your contracts and there aren't any clauses that jump out at you and give you a comfort that that there's a specific provision that you can rely on, well, then you look at sort of more the common law type protections that are out there. And this is what's known as the doctrine of frustration. This is where the events have had that we are facing have seriously affected the ability of the parties, one or both parties, to operate under the contract. And again, this is not simply a set of circumstances that has caused hardship. This is a significant event whereby the terms of the contract have effectively been amended, and thereby frustrating the ability of the parties to actually perform under the contract. Because it's has a serious effect for both parties, it is applied very narrowly, and it's very, very difficult to rely on this. You need to be able to show that there's a fundamentally different situation in relation to the contract, so that effectively the terms of the contract have been changed and that neither party had contemplated operating under those terms. So yes, that there is an ability to use these common law protections as well, but you should bear in mind that they are difficult to actually enforce. Any other questions, Kelly?
Yeah, so I was going to say, so that's looking at the terms of the contract, and then and looking at common law issues as well. Is there anything that's sort of non-contractual that we should be thinking about?
Yes, I mean, with any contract between parties, the parties can effectively ignore the terms of the contract and come to an arrangement as between themselves. It's when one party tries to do it unilaterally that problems arise. But both parties are in a position to renegotiate the terms of the contract, look at the commercial terms, and see whether there is some potential to change those. But when you go into any sort of commercial negotiation, it's very important that you're prepared. I always feel that there are two aspects that are vital. One, communication with the other side, and also preparation, so that when you're going into any negotiations, you're on top of all of the issues. So, I mean, there's a sort of a step-by-step program that you could look to apply. Usually the first stage is communicating, whether by email or telephone, with the other party to determine what the issues are, and do it in a manner that's non-confrontational. So the initial stage would be to determine whether there's anything that can be done without the need to get into complicated negotiations or into dispute. So the first step would be to an initial contact. The second would be to really to check your own position. I mean, for example, if you were a landlord in a lease and you had a tenant who was showing signs of not being able to continue, you don't want to go in there without realizing that, well, the term of the lease is coming to an end anyway. You haven't actually checked the lease. You need to make a thorough review of the lease before you actually engage in any negotiations with them. So it's really being aware of the current situation in respect to the contract. I think the next step would be to really find out a bit about in the case of a lease, the tenant. But the other side of the transaction, actually make do some investigation into their financial position. And there are various ways that this can be done, but it's important that you understand where they're coming from before you actually get into any sort of negotiation. And finally, in the making of an offer, it's obviously always important to understand, well, the effect this was going to have on your business and their business, but also, or is there an exit strategy to this offer? Is it open-ended, or is it for a period of time? If you're giving some sort of rent relief, you need to know, well, how long is that going to be available to the tenant? So it's really important to understand the relief that you're providing, but also have a good understanding of, well, what's the exit strategy? When do we return to normal, if at all? And then you make your decisions based on that. So it's, as I said, it's all about communication and knowledge and information being on top of all of the facts before you actually get into the negotiation process. Of course, there are other options available to parties to contracts, and those might relate to appointing outside administrators of one sort or another. And Kelly, did you want to have give us a few words on the types of options that might be available to appointment?
Yeah, sure. I think just to go back a step, what we've talked about in some previous webinars is about communication and reputation through this period as well. Even though you have certain rights under your contracts, you don't necessarily want to be enforcing them to the letter of the law at this point in time, because that could come back and bite you reputationally down the track. You know, no one wants to come out of COVID-19 as the assholes that weren't prepared to negotiate. I've actually heard of one landlord, Mike, that got the benefit of a 6-month rent-free period from the owner of the lessee got the benefit of the 6 months rent-free from the landlord, but didn't pass that rent-free on to their subtenants. So, you know, that doesn't put a relationship on good standing moving forward. But look, if it does come to a point where you do need to be enforcing your rights under contracts, then obviously some of the most severe ones are issuing statutory demands, or bankruptcy notices. Bankruptcy notices, you have to have gone to court and have a judgment first. We've talked previously about the fact that there's some moratoriums on those things at the moment. So we can't enforce a statutory demand or a bankruptcy notice until, I think it's mid to late September this year. So which would normally be 21-day notices. And you'd really only be doing these sorts of things after all of the negotiations had fallen over and you weren't able to come up with a commercial resolution, or with real recidivists. The idea behind, if we just look at companies and statutory demands, is it's a pay up, or we're going to apply to court to wind up the business and put a liquidator in there. A liquidator is essentially, it comes in as a bit of a grim reaper. It's the death of the company. Their job is to collect all of the assets of the company and distribute all of the proceeds amongst creditors in a fair manner. Alternates, if you are subject to, so on the receiving end of a statutory demand or a winding up application is that, Mike, as you suggested, we could look at voluntary administration. And voluntary administration is really a bit of a get out of jail free card. It's that there could be a future for the company, but you've got to deal with some legacy debt first. And that means that you put an offer to creditors as a whole to get back control of the company for cents in the dollar, basically. But again, these things are really extreme measures that you only really want to be going down that path if you yourself are in trouble, or if you've got real recidivists and negotiations aren't working.
Thanks, Kelly.
Okay, so I think let's move topics a little bit. We've covered off on looking at our contract reviews. We've looked at security in the form of PPSR and what those clauses look like. What about our business relationships? Mike, you touched on earlier that through troubling times, we might be looking at bringing in new equity holders and those sorts of things. I think there's certainly some opportunities around the place at the moment for those people that are happy to take a little bit of risk or be a little bit opportunistic in buying into businesses or buying businesses at bargain prices at the moment. What do we got to think about when we're looking at these sorts of relationships?
Sure. I guess whenever the economy gets into stress, that's a real test for the relationships you have within the business, whether it's just between two people or more, and in what circumstances you bring someone in, what circumstances you look to perhaps merge with another company. So there are a lot of issues that arise, but what is vital whenever you're considering these sorts of issues is whether you've got any sort of contract in place that governs the relationship. Hopefully you don't have to rely on that document, that it's all sunshine and roses and we all travel along nicely together. But we often see situations where that doesn't happen. And what's really important is that you've got some sort of agreement between the parties as to how to deal with specific sets of circumstances. Clearly, with companies and trusts, you've got constitutions and trust deeds, which form the basis of the entity itself, but it doesn't usually deal with dispute situations or situations where one party may be wanting to exit the business, or in extreme situations, one of the parties has suffered some sort of health issue or even a death scenario. So your constituent documents, your trust deed and your constitution are not going to deal with those sorts of events. So what you're looking to then put in place is a document that will deal and put in place structures with situations that are often emotional and often involve some level of dispute. We're very big fans of shareholder agreements and unit holder agreements, and of course, if you've got a partnership, you have a properly drawn up partnership. The shareholder and unit holder agreements, what they're doing is extending the reach of your constitution or your trust deed to cover these sorts of arrangements. So in the event of an exit, say, or an event that's occurred that might trigger an exit, your shareholder agreement or unit holder agreement will actually make provisions for that. So you'll often see in a shareholder agreement clauses that are in the nature of a put and call arrangement, where you'll have a list of trigger events, and they may range from one of the parties no longer being employed in the business, which is often the case with smaller private companies, or one of the parties has gone into receivership or liquidation, bankruptcy in the event of an individual. But it could go through to divorce of one of the parties, obviously death and disablement of one of the parties. And all these events are determined beforehand. You have a list of the trigger events that will trigger the right of the unaffected party to buy out the affected party. So and it's often done by way of option, and it's often done by way of a put or call option, which allows either party then to exit if one of the trigger events has occurred. Other types of clauses are drag-along and tag-along style clauses, and these are really important in situations where you've got minor shareholders. A drag-along gives some protection to the majority shareholders. They can force a minor shareholder along to come along in a sale. So if you've got, for example, 75% of the shareholders who are wanting to sell the business or the shares in the business, they can actually force the minor shareholders, the 25%, along for the ride. So it's protecting the majority shareholders. And a tag along protects the minority shareholders, because if 75% are wanting to sell, your minor shareholders can say, put their hand up and say, well, we're tagging along as well and wanting to sell. So it's in a situation as we have now where there are going to be businesses in stress, there are going to be businesses with minor unit holders or minor shareholders. These sorts of clauses will allow the majority to really determine how the business is going to go forward. The more basic types of transfer clauses are known as preemptive rights, and these are often contained in the constitution or the trust. And it's effectively meaning if someone's wanting to sell, they have to offer their shares or units to the other shareholders or unit holders before they go out to the public. But your shareholders agreement will then determine the process of how that's to go, the amount that's to be offered, and whether, in fact, there still needs to be shareholder or board approval to any transfer. And so your shareholder agreement, unit holder agreement will make provision for that sort of thing. Financing is often an issue on any sort of buyback or transfer of shares. How do you finance that? How do you put a value on your particular equity? And again, your agreement can make provision for that. And there's lots of different ways that can be done. From a valuation perspective, you can actually insert a formula into your agreement that's to determine, well, if someone wants to sell the shares, you sell it in accordance with this formula. And that formula will be the same one that you used when you came into the business. So there's a certain continuity in that regard. The problem with formulas is that they often relate to historical financial results. And in a situation where we're faced with now, where people may have had a good 3 years leading up to the crisis, but now can see what's happening, what's potentially going to happen in the next 3 years, well, it then actually acts as an incentive to exit, because you're going to be calculating your value based on your historical performance, which can give you a good result if you know that your prospects are not particularly rosy for the future. So those formulas can be useful, but can also be a little bit of a disadvantage. Clearly, you can just make provision for a third-party evaluation that is done. So when someone is exiting, a valuation is done by a particular third party. So it's done at the time of sale, and then you would hope that with an independent valuation, the prospective outlook for the company is taken into account. The actual payment of the purchase price, again, can be a real issue, because it's putting a lot of stress on those who are remaining in the business who may already have some financial stress because of the COVID-19. So what is often the case is that you'd make provision in your contract to allow for the payment to be made over a period of time, and that can be determined by when they leave. So if they leave within a 3-year period, well, they're only going to get paid out over a longer period of time. So there's different ways that you can manage that, and you can determine whether there's going to be an interest component in the payment as well. Obviously, there are situations that you can provide for a financing mechanism, and these are more in the situation where there's been a death or disablement associated with the business. And it is possible to then insure for those events. And of course, that involves cost of your insurance premiums, but it does allow, in the case of, say, death, a life insurance premium is paid, and that is then considered to be the purchase price for the deceased party's interest in the business, thereby relieving the surviving proprietors any sort of financial obligations in respect of the payout. So it's those sorts of things again that should be considered in advance and put into your shareholders agreement.
And is there a right time to be putting a shareholders agreement in place, Mike, or a unit holders agreement or a partnership agreement?
The right time is obviously when you first get into bed together. So whether it be someone buying into an existing business, it would be at that time, or whether it's two or more parties getting together and starting a business, that's the best time, because everyone's on good terms. Everyone is some equality to the situation. Obviously, it puts a bit of a stress on the proprietors who are starting a new business, because there's a cost to doing these things, and most small businesses will have a limited budget, and so that's what often puts people off, is the cost of doing these things. The trouble with that is that if you try and do it down the track, people's positions may well have changed. They may have a different attitude towards their partners, and it becomes a little bit more of a negotiation process in getting your shareholder agreements in place. So it can take a bit longer and be more expensive if you do it down the track a bit. But to be honest, if you don't have one, now is a good time to do it, because it's a document that you put in your bottom drawer, hope you never have to rely on it. But if you do need to rely on it, there's usually a dispute scenario, and it provides you with a clear mechanism for dealing with disputes, dealing with exits, and so on. So it's a vital document, and certainly as lawyers, whenever there's a dispute, the first thing we ask is there a shareholder agreement? Because there are countless examples that we've had to deal with where there hasn't been a shareholders agreement, and a minority shareholder can effectively blackmail the majority shareholders. They can simply say, well, we're leaving the business, we don't have anything more to do with you, but we're not selling our shares. And you can't force people to sell their shares. There's nothing in the corporations law that allows you to force a minor shareholder to sell his or her shares. So it can become an awful problem for the business going forward. If the business wants to sell out to someone and that the buyer wants 100% of the shares, well, it puts the minority shareholder in a very nice position to be able to negotiate a very handsome payout for their particular interests. So it's vital that these documents are considered. If you can't afford it doing it up front, well, when you can afford it, you should be putting it in place.
Yeah, I think it's a bit like an insurance policy, isn't it? You put it in place hoping that you're never going to want to use it, because I think inevitably everybody starts off business all best mates and friendly, thinking nothing bad will ever never happen. But the time when you need it the most is when relationships are broken down.
And we're in a position at the moment where there's a lot of stress being put on relationships. I'm dealing with one right at the moment where two partners are in a business. One guy's doing all the work, the other guy's not. How do we deal with that? There's no shareholder agreement in place. It becomes, it can actually result in the business coming to an end, or that you close down one entity and somehow set up a new entity to continue the business. There are issues with doing that. But your shareholders agreement is also going to deal with things like the appointment of directors, when you need to have a special resolution of directors. So there may be particular actions that a business considering, whether it be a sale of the business, or bringing in a third party, or borrowing money. You need something more than a majority interest, a majority resolution. So it's important when you have a shareholders agreement, you're keeping an eye on what's in there, because you might find that one party wants to sell the business, the other party doesn't. Well, how can that be achieved if you need a 75% special resolution? So you need to keep a close eye out for that. Also, obviously, things like profit distributions, how that's dealt with. And this is important, particularly with unit trusts, where you're obliged more or less to distribute out all of your profits each year. But typically, the unit trust will retain some as working capital. Well, your unit holders agreement should really make provision for that, so that all the parties know that, well, for tax purposes, you get 100% distribution, but in real terms, you're only going to get, say, an 80 or an 85% distribution. So it's, those sorts of things are in your unit holders agreement. And of course, in good times, no one worries about that. Oh, plenty of money to distribute out. In times of tough, suddenly those sorts of issues become really, really meaningful. And of course, you know, the winding up of a company's or a unit trust will be provided for in your unit, in your agreement, what circumstances that will happen, whether you need unanimous resolutions and so on. So
yeah. Okay. And look, I think, thanks for that, Mike. I think just to wrap up, I think it's important to recap on something that we mentioned in our last webinar, and that's that I talked a little bit about moratoriums earlier, and there's also a moratorium on insolvent trading till about mid-September as well. So that means now, before the tsunami hits and before all of the government surplus has stopped, is the time to be looking at where is your business going forward? What are the things that need to be changed? What needs to be implemented? Do you need to be looking at your terms and conditions and inserting security clauses in them to make sure that you can put your registrations on the PPSR? Do you need to be looking at shareholders agreements to make sure that if someone wants to exit in the future, you've got the rule book sitting there ready to go? What does the viability of your business look like moving forward as well? Have you got the cash flow to survive without government stimulus payments? Those sorts of things. Now's a really good time to be making an assessment about that, putting a plan in place, because you're not going to, if your determination is that, you know what, oh shit, the business isn't doing so well at the moment, can't pay its bills at the moment, but if I put a real good plan in place now, come mid-September, I think I've got a viable business moving forward, and I'm not going to be liable for insolvent trading. So I think there's some real opportunities for directors to take advantage of those moratoriums right now, to be negotiating with creditors, or even, you know, having a good, hard, honest look at your business, and if it's just not going to survive, call it now. Stop everybody's pain. Stop leading your creditors on so that they think they could turn a corner, but you don't actually ever going to be able to pay them. And take the stress off your shoulders and actually deal with the reality of what your business looks like right now. So I think now is really a good time to be taking stock of where your business is at, and hopefully some of the things that we've discussed today you can think about while you're having a look at what needs to be implemented post-September this year, or it could be earlier if some of the government stimuluses finish up early. We're just about out of time. Were there any final thoughts from Henry or Michael? Were there any other questions from the audience that you wanted to bring up now?
Nothing more from me this day.
Okay.
Nothing further from me, Kelly.
Okay. It doesn't look like we've got any questions from the audience either. So thank you everybody for joining us today. If you want to stay up to date on any articles or events for Murfett Legal, head over to our website, www.murfettlegal.com.au. Sign up for our newsletter. That'll keep you up to date on everything that's happening here at Murfett Legal. And if there's a specific topic that you're interested about hearing from us on, feel free to drop us an email, and if we've got enough people that are interested, we'll put together a webinar on the topic, or we'll just reach out to you personally. So I think that's it. We're going to finish up a couple of minutes early today. Thanks again for joining us, and we'll see you all next time. Have a great day.